On Law Weekly today, we look at the latest move by the National Assembly to amend the Constitution. Our discussion shows up possible areas of amendment and how the lawmakers can fast-track the process. My guest is a senior advocate of Nigeria, Olukayode Enito. Also showing on the program, reactions trail the latest verdict of the British court awarding costs against P&ID and in favor of Nigeria. Two legal practitioners share their views on the implication of this, plus our weekly recap of the trending legal stories in the news. Hello and welcome to the program. I'm Shola Shieli. The Senate Committee on the Review of the 1999 Constitution has reportedly received 40 bills sponsored by senators. The committee has also extended the deadline for submission of memoranda to September 18 to give Nigerians more time to send in their inputs for consideration ahead of the proposed review. But there are those who say that the constitutional review process is fast becoming one too many. I sat down with a senior advocate of Nigeria, Olukayode Enito, to get his views on whether the country needs another constitutional amendment review and for what issues.
There is a need to amend the Constitution. However, what we need is not a piecemeal amendment. There has been 3 alterations to date. 2 of those alterations have to do specifically with election, interest of the politician. That should not be. It should not, and every time they amend, it's because something touches them. So the question should be, what exactly do they want to do now? So that we can tell them straight away, go ahead, or no, we don't want. But we've had several assemblies, and I'm not talking about legislative assemblies, convocation of people. President Jonathan set up a constitutional review committee of several people who are being paid, I think, 4 million naira for the exercise or for each month. That took such a long while. They came up with a report. What has happened to that report? What they should do is pick all the books, all the several reports, all the white papers, let them do the work of going through that, and then come up with, these are the specific things that should be tweaked in this Constitution. And then we will take that and we'll move with that one. Not every assembly, like somebody said, it's a jamboree. We do this every legislative season, and each one only comes up with politically motivated amendments or alterations. Let's do the whole thing once and for all. There are several things that we need to touch.
So you say that instead of considering a piecemeal amendment, they should look at the 2014 National Conference and dust up all the white papers and consider that.
Exactly. What they want to do, it's already somewhere in there. You see, there's no point reinventing the wheel. And that's why people are saying their motivation is just to spend money. They already have committees in place. Let those committees go and take those reports. Let them do the work. Get in the trenches and come up with exactly what you think you want to do using those reports that already exist. There is the issue of fiscal federalism. It's been touched. There is the issue of whether we should even have a unicameral legislative system. All of this have been discussed. Discussion and memoranda, this is no longer what we need. We need to move forward. We can't keep going around the mountain.
In your opinion, what areas of the Constitution do you consider as needing urgent amendment?
Right now, I'll be very glad if they were to come up and say, look, we want to deal with the issue of how not just collections, but distributing resources in an even, equal, and egalitarian manner through the federation. This habit of, in one section, resources belong to everybody, and in another section, resources belong to individuals, it should stop. You cannot have people in Lagos, in Aba, in Port Harcourt drinking beer, and you collect VAT, and then this VAT is put in a purse that everybody shares, and then there is somebody in Kano going around breaking bottles of beer who is going to share and take a large portion from the proceeds of those who are drinking beer in Lagos, Port Harcourt, and everywhere else. That is unfair. And the Constitution itself says that equity, fairness, justice, and an egalitarian society is what we should have. So in that itself, we are already going against the spirit of the Nigerian Constitution.
What's the solution to this VAT issue?
There is already in place a principle of derivation. Implement it across board. For the oil and gas industry, the oil producing states have a 13% derivation that they get. So, a state that gives the huge or the largest chunk of VAT should also get, the state that gives the largest chunk of corporate tax should also have something by way of derivation. When you do this, you see, what is fair is fair. Federal character should be based on merit. I'm all for the governor of anywhere being from anywhere else, if he is the best, whilst observing federal character, the quota system, and all of that. Whilst we want to observe it, it should be observed on the basis of merit. And where there is no one that meets up, please move to the next place and get someone. With regards to the judiciary, there are a lot of things. You see, our Constitution is saddled and full of procedural issues. Procedure is constantly changing. It will change to meet circumstances. That should not be a constitutional provision. The Constitution should deal with the soul, the spirit of how the law should be executed, not with the process. For instance, why do we have in the Constitution how an appeal should be done? The procedural aspect, you need to seek leave, you need to... No. This should be taken care of by rules made by the President of the Court of Appeal, the Chief Justice of Nigeria, the heads of the several high courts. They make rules. So leave them to make their rules. But let the Constitution deal with the substance. Lay down the core and let the rules build around it. So there is need to tweak that aspect of the Constitution also.
Still on the judiciary, one suggestion that has been put forward is the creation of regional Supreme Courts to handle appeals arising from civil and criminal cases, while the Supreme Court in Abuja handles constitutional matters and disputes among the various arms of government. Do you think that there is merit in this suggestion?
There is. However, we must be careful, such that we do not end up with something worse than what we have now. Right now, we have several divisions of the Court of Appeal. You find out that there are conflicting decisions. One division says one thing in respect of the same set of facts, the same rules, another division expresses a different view. So if we want to have regional courts of appeal or regional Supreme Courts, it has to be such that those matters will end there. So matters that will go to the Supreme Court of Nigeria will be issues that deals with that are of constitutional importance, that will help to lay down some serious policy as to the running of government, as to the way and manner that the nation is hooked together, for want of a better word. So, for instance, things like landlord and tenant. Why should a landlord and tenant issue get to Supreme Court of Nigeria? Why? It starts from the magistrate court, gets to the high court. It should die a natural death in the court of appeal.
Natural death.
Natural death. That should be the final court. The same thing, of course, we already have that. State Houses of Assembly, National Assembly, petitions, election petitions, and all of that. They all end in the Court of Appeal. Nobody has lost anything because that is happening. So why can landlord and tenants not end in the Court of Appeal?
At the recently concluded 60th Annual General Conference of the Nigerian Bar Association, the president made a case for speedier dispensation of justice. He called for reforms that would see criminal cases decided within 12 months and civil cases decided on most within 15 months. Is there any need to tweak the Constitution to achieve this?
We don't need constitutional amendment for that. And I'll give you an instance. I was reading an account, some form of parody, history, and light-hearted account of the Ondo State gubernatorial election petition of 1981, was that 81 or 83? Between Ajasin, Governor Ajasin, and his deputy, Omobori Owo. Can you believe that the entirety of that process, without a constitutional provision, it started in August, it ended in October, and it went from the election tribunal, Court of Appeal, and Supreme Court. Guess how many days it took in the electoral tribunal? It took the whole of 5 days.
From start to finish?
From start to finish. No adjournment, nobody requested, nobody had to oppose anything, everything. And they had about, I think about 50 witnesses on both sides.
What has changed? Why do cases now drag?
We changed. We lost sight of the big picture. So that matter, Court of Appeal, took less than 3 weeks. Everything took 3 months. The Constitution was not amended. Today, with constitutional amendment, it takes us 180, 60, and 30 to do petition. Why? We can do these things. The judges, they are tasked, overworked. But in that particular case, what was happening? Every day after the sitting, the presiding judge was summing up the facts every day, such that by the end of trial proceedings and address, it took them the whole of 1 day. to do, and it is possible.
Welcome back. A UK court on Thursday ordered the British Virgin Islands firm Process and Industrial Development (PNID) to pay £1.5 million to Nigeria within 21 days. A statement from the Office of the Attorney General of the Federation and Minister of Justice, Mr. Abubakar Malami, says the court ordered PNID to pay the money to Nigeria to cover the legal costs incurred by the federal government in successfully obtaining the court's permission for an extension of time. What is the implication of this, especially as the country prepares to open its defense? Two legal practitioners share their views.
To me, well, it's a good development. At least Nigeria can cover the cost of whatever they've spent to set aside to get that motion for extension of time to enter into full trial. Well, be that as it may, the effect or the impact of the judgment or the verdict delivered on Friday goes a long way to show that the whole transaction from the onset had been issued by, or the contract signed by PNID and the Nigerian government was founded on fraud. And fraud in our legal jurisprudence is one of the vitiating elements of contract. Now, you see, from the judgment, if you read, especially when you get to paragraph 2.11 to 2.26, down to 2.43, 2.47, those things are clear. The Nigerian government has been able to show the world that, first of all, the whole transaction was built on fraud, on fraudulent transaction, and it also goes also to show that the counsel that was engaged initially to defend the Nigerian interest compromised his stand. It is there in the judgment, especially at paragraph 2.226. The judge said that there's a prima facie case against the counsel of Nigeria. Why is this so? Because the counsel went about giving money to people. At one breath, the people that money was given to said the money was a loan. And when asked, have you paid the loan? They said no. Him on his own part said the money was a gift. Gift in what sense? What are you gifting them money for? These are people that are supposed to go and defend the interests of Nigeria, giving them a gift. It erodes on his integrity. It means he has a lot of questions to answer. He needs to answer to the Nigerian people.
The court noted, Justice Ross Cranston, that Nigeria has now been able to establish a prima facie case of fraud for which it is now invited, albeit out of time. And you will note that Section 67 and 68(2) of the 1996 Arbitration Act limits time within which such applications can be made. A similar section is provided for in the Nigerian Arbitration Act under Section 2930, which prescribes when an application or when an award can be set aside. And so the same thing happened in the UK court. Unfortunately, Nigeria did not take advantage of that time limit, and that is why we are now seeking to extend time for us to set aside the award. So the court has granted that application, and not that the court has set aside the award. A principle of law, which is that cost follows event, simply means the court will award the cost of a litigation or an arbitration to an unsuccessful party. And that was what simply happened. The court, having granted Nigeria's application on September 4, would only allocate the cost of that hearing to the unsuccessful party, which is the PNID. I believe this may not be time for Nigeria to consider attempting to negotiate or settle this matter. Reading through the judgment or the ruling of the court granting this extension, one is almost persuaded that some things went wrong. And for those reasons, the judge himself appeared to be already persuaded, that Nigeria may have a good case. And for those reasons, I believe the Nigerian government should pursue this. Now, what is the lesson to be learned from this? Two things. One is that as a country, as a people, Nigeria must keep good records of every transaction that it gets involved in. And secondly, is that the Nigerian government must start treating all its transactions the way the private sector will treat same. And these are some of the issues that arose that obviously led us to where we are as a people. But I think it's a good step. I don't see it as a success, therefore I'm not able to celebrate it. Rather, I think it's an opportunity for Nigeria to double up its effort in its investigations and information which will be submitted before the court to support the criminal allegation.
And just before we go, here's a recap of some other legal stories we're tracking.
We'll begin with the report the trial has continued in the alleged money laundering case against the former Minister of Justice and Attorney General of the Federation, Mohammed Bello Adoke and Aliyu Abubakar. They are facing a 14-count charge before Justice Iyan Ekwo of the Federal High Court, Abuja, for allegedly laundering about $6 million. The Economic and Financial Crimes Commission, the EFCC, presented 3 prosecution witnesses against the defendants. One of the witnesses, a businessman and bureau de change operator, told the court that he knew the first defendant, Mohammed Adoke, but had not done any business with him. He, however, testified that he was engaged by the second defendant to convert 2 billion naira into dollars. He said part of the money was handed over to a lawyer. In a related case, the EFCC has rearranged Malibu Oil and Gas Limited, Aliyu Abubakar and 6 others before the same Justice Iyan Ekwo of the Federal High Court in Abuja. They were rearranged on a 67 amended count charge bordering on money laundering to the tune of $875.7 million. At the proceedings, the defendants pleaded not guilty to all 67 counts, and 2 days after their rearrangement, trial commenced with the testimonies of the witnesses. One of the prosecution witnesses told the court how Malibu Oil and Gas Limited and 6 other companies charged with fraud in the Oil Prospecting License 245 transactions had allegedly violated the money laundering law. And in Lagos, the state judiciary has called for applications for members of the legal profession who are interested in being appointed as High Court judges. The Lagos State Judicial Service Commission put the notice out via a call for expression of interests. The notice, signed by the Chief Judge and Chairman of the Judicial Service Commission, Justice Kazim Alugba, was placed on notice board on the premises of the State High Court. It called on suitable persons interested in being appointed as judges of the High Court of Lagos State to express such interest in writing within 14 days. And we round off with the report that the Chief Justice of Nigeria, Justice Tanko Muhammad, has inaugurated 85 judges to serve on election petition tribunals set up for the forthcoming governorship polls in Edo and Ondo states, as well as by-elections in other parts of the country. At the swearing-in ceremony, the CJN urged the judges to strive to earn public trust, as their conduct will be publicly dissected and thoroughly scrutinized. He also urged them not to submit to blackmail or intimidation and advised them to strive to earn the accolades of the public.
There's no doubt that temptations, tribulations, intimidations, and even blackmails may be unleashed on you. But as thoroughbred judicial officers, you must guide your loins to rise above all and do what will earn you accolades in the court of public opinions.
And here's where we adjourn till next week. Don't forget that you can watch again this episode of the program and past episodes on our YouTube channel. I'm Shola Sheyeli. Thank you for watching.